We are live.
All right, we're reconvening our afternoon hearing on H86, and we're welcoming Adam McCrasson.
Thank you, Madam Chair, members of the committee. My name is Adam McCrasson Group, here with the Vermont Association for Justice, bringing testimony that's focused on the safety perspective of the proposed legislation, and jumping to the end to raise some cautions about it that I'll now unpack in my 15 minutes with you. So since this is the first time I'm here, just letting you all know when you see me, I head a firm that's many multi-client. We have dozens of clients, and often they are their own voice. And it's unusual for me to testify, but I'm pinch hitting here. But do know that we understand there's great interest in this legislation, and I've worked with this association to bring in some legal experts who will be down in Senate Judiciary on Thursday. And I now have the benefit of having spent a bunch of time with them in preparation. So this testimony, for the advocates to know, is more well-informed than my pinch hitting in the Senate. We bring to you the Judiciary Committee testimony. Our focus is safety. This bill is at the intersection of your constituents' safety on commercial premises and the application of SALT. That's where this legislation is playing out. The current law that governs safety in this area is born in the common law of torts, and it essentially is this: that every corporate premises property owner inviting you here for a commercial transaction has a duty of care to be responsible about hazards that they know or should have known about to fix them and make it safe. In this area of injury, jumping right to the middle of my testimony, please know that no Vermonter, none of us in this room, leave our house without assuming the risk of certain hazards. And so if you are going out in a snowstorm, or you are going out without practical shoes on, the current law holds you accountable for that and does not allow you to blame someone else if you're injured. Okay, assumption of the risk is embedded. Okay, now backing all the way up. I'm coming to you from the perspective of safety. Somewhat disappointed that the proponents I've monitored 10 plus hours of testimony, maybe 20. None of the focus has been on safety. The proponents are not promoting how the standards they're bringing forward to the General Assembly, saying adopt this as the policy of the state, and you will be making sure that premises are safe. Okay. In fact, the safety standards that the bill proposes to provide immunity for don't exist. They're on a blank sheet of paper. They're not before the General Assembly. You are not judging, are these the standards we want to adopt to set the law of safety on black ice at the pharmacy when the elderly Vermonter gets out of her car to go get her prescriptions? Okay, now backing all the way up. Torts 101. Brace yourself for law school in 5 minutes. Okay. I've been at this with this client for 25 years in this building, so this is not my first attempt at Torts 101 in a committee. Often it doesn't work out well, but that's because the nature of torts is a complicated area of law. But drawing from these resources, okay, and launching into it by suggesting the measure of the New Hampshire law for us is how many people how many people are still safe? What's the injury track record of the law? Not the number of lawsuits. Because jumping at the very end, they're short of being draconian here, it's very hard to block a lawsuit, to say, if you do this, you will not be sued. But let's get into torts. What is a tort? Injuries occur every day. A driver falls asleep at the wheel and crashes into a tree. Someone trips down the steps. Operations are not always successful. Bad things happen every day. Very often, though, people are injured when someone else is responsible. A homeowner fails to repair the cracks on their sidewalk. A physician carelessly doesn't read the records and misdiagnoses cancer. Or passengers are killed in an apparently minor car crash caused by the gas tank rupturing in the rear of the car. Many of you will remember that. That was one of the most famous tort safety standard leaps in the last 50 years, right? The car had the gas tank in the back and there was no government regulation about where to put it. And it was tort law, people being injured, and the car companies being held accountable for that unreasonable design that moved the gas tank into the middle of the vehicle. Okay, what if we had no legal system to deal with injuries like these? Three things. First, people would have less incentive to avoid injuring other people. You can do what you want. If you hurt somebody, tough luck for them. Well, tort law, which came from England on the boat, the common law, says no to that. You have a duty to other people. Number two, victims of accidents will be left to their own resources to pay for medical expenses, lost wages, property damage, and other consequences of the injuries they suffer. For most victims, that cost would be significant. For the unlucky few, it will be catastrophic. If someone's corporate carelessness causes you to be injured and you have a lifelong medical care plan, you can't earn to take care of your family, that's a consequence of the tortious behavior and someone needs to pay. Well, tort law says it's the wrongdoer who has insurance, which is one of the phenomenal ways we civilize in this space. So that if you hurt somebody, they're going to be okay. Without that insurance, when someone is hurt because someone is careless, there's going to be medical bills and they're going to be paid. And if it's not the property and casualty insurer of the Walmart that has the dangerous premises, it's going to be Blue Cross Blue Shield. It's going to be Medicaid. It's going to be Medicare. If someone's destitute because they can't earn a living, because they broke their back through no fault of their own, the trail continues to the taxpayer. So rest assured, when someone is hurt by carelessness of others, someone will pay. The Judiciary Committee, the tort law is allocating who. Number three, if we had no tort, it would just not seem fair that people could freely inflict harm on others. And so fairness. Fairness is if you carelessly hurt someone, that's on you. Okay. These are not controversial notions. I think they were born of hundreds of years of the common law being sorted out in Europe before it was brought here, and it is the most commonly occurring consumer protection writ large, tort liability. Legislatures, Congress, agencies cannot write rules that govern at a micromanagement level every interaction between commerce and people. You just can't. You wouldn't want it. It would be like the nanny state gone mad. So like there's some basic principles that are naturally occurring that this bill proposes to wade into and get in there and change things. Okay. Hundreds of years, tort law, good incentive. Let me skip the rest of that piece of the torts class, which is just phenomenally fascinating. We did not create this justice system. This thing where if you're harmed, you're in an auto accident, you were just sitting at the stoplight, you get massively rear-ended because someone was reading their phone. Someone crosses the center line and hits you because they were reading their phone. Well, don't shoot the messenger. I represent the people whose offices those people end up in saying, will you help me get my life back together? I'm out of work. I have medical bills, no fault of my own. I have this auto insurance that's inadequate. Who knew? And so the folks I work with see this pain and suffering come in, and they have us here working with you to kind of illuminate the tort law. The recent trend in this building has been use tort law to create more access to justice. Not what this bill does, which is attempt to clarify it, but probably reduce access to justice for victims of irresponsible commercial behavior. Recent examples, the Civil Rape Shield came out of Senate Judiciary, this elimination of the statute of limitation for child physical and sexual abuse. A few years ago, we worked with the House Judiciary Committee to clarify the dram shop law. This is the tort law that applies to bar owners, nightclub owners, serving alcohol. And in that area, there's a couple aspects of it. Strict liability. If you serve someone under 21, like you're in the car with them until they're sober and your insurance rides along. If you serve someone who's dangerously intoxicated, it becomes a question of reasonable circumstances. If you serve after hours, you're in the car with them until they're sober and no one else is hurt. You have insurance for that, but it's a serious responsibility to serve alcohol, right? So when you get into torts, now there's a Vermont aspect to this that's unique here. And it's meaningful because at the end of the day, you have people in pickup trucks spreading salt, and you want to try and go through this circuitous law I'm laying out to send them a signal to make it safe with less salt, which, by the way, great idea. You know what I mean? Like, we definitely want to attack salt. It took 100 years to make the lake polluted with phosphorus. It's going to take 50 to get it out. This is a great fight. The Northeast states are into it. We're doubting that this is the place to go this fast when the safety standards are not written. But rest assured, this is a worthy endeavor, and there's even ways, you know, we could envision this moving forward and helping even on liability. But what is the litigation environment in Vermont that is really going on? Because before the General Assembly abrogates people's rights, you want to make sure it's not chasing urban mythology, chasing feelings, chasing perception. It's a slippery slope that ends with Grandma Murphy falling on black ice outside CVS that should not have been there a week after today. We haven't had any storms. The drain pipe lets loose. There's black ice. You know, you call is the store paying attention and calling and getting it taken care of? Question one. New Hampshire handles that differently. Is the contractor who's in charge of making those premises safe rising to the occasion and coming in to take care of it? Or are they checking their app to make sure they followed the protocols to be like, well, we were there recently. So what's the litigation environment? We're the least litigious state in the country with the lowest jury verdicts and the most strict jury standard in the country. Now, bold statement, I'll back it up here in this way. Coming with the common law from New England came this notion of 12 jurors that must be unanimous. 100% makes sense in criminal law of the land. Okay. In the civil space, you know, it's where juries are weighing the facts. They're trying to find what was reasonable. What made sense here? Vermont requires 12 jurors in every civil jury standard. And they have to be unanimous. Only a handful of states require unanimous verdicts. So stated differently, if you're the commercial salt applicator and you've been sued, your defense, your insurance company provides you with a lawyer. And you have a policy for if you are found negligent. Among the first things they're going to be able to tell you, the insurance defense lawyer for the salt applicator, is that we, the defense, only have to convince one juror of our side of the story, and it's lights out for the plaintiff. Just one. Well, New Hampshire, it's 4/5. It's like I quibble with the tort system equivocation. It's always cherry picking data, but like New Hampshire is not a tort regime like Vermont. You know what I mean? And Exhibit A is they have non-unanimous civil juries. You know what I mean? You can have two people who are just like, no way, no how. You know, I didn't disclose, but my brother's a, you know, something that makes me hard line on this. We want justice to be allocated. So the civil jury standard in Vermont is the strictest in the country. Therefore, it's very hard to prevail. Therefore, your constituents who are worried about being sued have a current law that really has the highest bar possible. So we don't wait. So the General Assembly has been reluctant to wade into these situations, knowing that we're not Jersey, we're not Florida. There's no billboards. There's no venture-backed capital firms. the lawyers in our association are small businesses. They oddly only get paid out of someone who's wrongly been hurt's recovery. If it succeeds, it's an odd system. I'm not here to defend it, but it's what you all have created. Now, negligence, taking the torts class to the next level. What is it? Because you're proposing to scratch it out in this bill and supplant it with the safety standards here on the sheet of paper, saying if you meet them, you cannot be found negligent with regard to salt application in this area. What is negligence? It's duty, breach, causation, damages. You have a duty to, your store has a duty that when he comes in, is generally safe to get from the car to the store. Not in a snowstorm, okay? And not if you're wearing stiletto heels in the winter, okay? But generally, so duty, that exists. Breach, the customer comes in and says, super black ice out there. The melt happened and the freeze happens. Well, you have to carelessly not take care of that. Like, whatever, I can't deal with that today. Cross my fingers. Causation. That led to, on the way to the car or on the way to the store, a fall on black ice that was unreasonable to be there. But the fourth piece, there have to be actual damages. It's not my, I'm upset I got hurt. Lost wages, medical bills, pain and suffering. And you have to have all four of these and get 12 jurors to agree that the set of facts applied to these four standards warrant recovery. Insurance defense lawyers are professional at defending you, and you're just like, it just fell and I can't go to work, And so this now I've laid the foundation, Madam Chair, and I know I'm trying to do this in good faith, the legal class of torts. I get, because you're at the intersection of safety and salt. And I know all the testimony is salt is bad, get it out of the rivers. I'm here to say, well, then they really need an equal public interest. The current law says safety matters. And we want to carefully track what we're going into to know what the standards are to provide safety on commercial premises. You brought the customer there. So, all right, now, in the environmental space, so a little chapter shift. You want to encourage regulatory certainty and business activity and environmental protection and consumer safety. Say those four things. In the typical moment like this, using logging or farming as examples, you have an environmental law that's going to penalize someone for hurting the environment. Too much salt, you're hurting the environment. Typically, the Environment Committee is saying, well, there's penalties for that. And we want to help, right? Those four columns, where do we line them up? Best management practices, AMPs, AAPs, right? Water bars, fencing cows out of streams, grass strips. Well, the environmental committees before you have said agencies create those best management practices, and then the logger, the farmer gets the benefit of presumptions of compliance with environmental laws. Okay, so I'm sticking my landing on this one. These types of practices, standards, guidelines, typically give you protection from environmental enforcement. It is unusual to go into tort law. Okay, I'm just going to, it's unusual to go there. Now, incentives to do this stuff, beware the illusory. I'm going to unpack that. I listened to the New Hampshire experts and I have some stuff for you on that in a moment. But the idea of incentive, well, the first incentive to not spread too much salt is it costs a bucket of money to put it in the back of your truck. And so I have, a notion that where the mass volume of salt is being deployed, B-Trans in municipal trucks into our environment, there's acumen and interest in these guidelines, these safety standards, not for safety, but for finances. I embrace that all day. The second reason to do this is protecting the environment, the certification. You can create incentives with this law that say, if you take these classes, you're green certified in the state of Vermont, and that gives you a marketplace leg up. And I don't know if there's pollution law enforcement that could be woven into this. I do know when you get into tort law, we've got a lot of unpacking left to do. Other states, yeah, New Hampshire started this with a half-page bill, and the energy of their presentation was great. And it's super earnest and thoughtful. And you got to love the idea that all these certifiers are there learning how to do this better. Good. It got really cloudy when you got into what does it mean for litigation. You know, and I heard there's still lawsuits, right? And so you would have to, this building would have to enact a draconian law to ban someone getting sued. If someone's really hurt, quadriplegic, right? Fell on black ice today, made no sense. There's going to be litigation. And so it's very hard to, the idea, if you pass this law, people won't get sued. That's just not real. So New Hampshire's waded into this. Other states have not. The municipal focus is great. For the commercial folks, we would love to see these standards in place so that they could exist. And then we could judge them based on their clarity for what they're doing for safety. This has some cart before the horse aspect to it, as far as the General Assembly goes. Now, wrapping up, an ounce of prevention is definitely worth a pound of cure. Our ounce of prevention is some salt. And, the pound of cure is someone not grievously harmed by a law that says, by definition, we have decided that we, the General Assembly and the Agency of Natural Resources, have looked at every possible circumstance where this could be relevant in the real world, developed guidelines that are the equivalent of the safety standard, the code of conduct that governs this area. It's a tall task. We would love to see those standards and sit before you and talk about how they can be woven in. Now, if you created the safety standards, so ending on a positive note, if you pass this bill without the immunity provision, you would be creating a standard of care that would help a commercial salt applicator in potential litigation. It would define the standard of care that then people would argue about on some levels. And so right now, it is vague. It's the reasonable person. What would you reasonably have done? If you want to wade into the government saying this is what reasonable is, it helps the commercial salt applicator say, I met that standard. This suit should be dismissed. That's different than what this bill does, which says if you follow these standards, it's a matter of law that you can't, there's in no way were you careless and unreasonable in any way in the application of, at the intersection of salt and safety.
Thanks for your testimony. Couple questions from me and then I'll open it up. How many slip and fall cases are there in Vermont every year?
Not a lot.
How many?
Don't know, but not a lot. Most of these situations end up in an office of our clients where a lawyer is saying, this isn't really a case to be brought. It seems like a bad situation, but we have the Jim Swift from Lame Rock and Richard Rubin from Barry attorneys, and I was in the Zoom with them this morning talking about it, and the cases they do have are pretty sympathetic. They're Vermonters who are not looking for unfair like they're not trying to get ahead. And they're mostly older people on commercial premises trying to pick up prescriptions.
So if I understand this bill correctly, it's not exempting anyone from liability. It's limiting liability for if you are reducing the salt. It's narrowing the scope of the liability, but it's not eliminating it in its entirety, and it's focused on the salt piece of it. So that's one kind of part of this, but then also we've taken testimony that the BMPs can actually make the utilization of salt and its applicability to making something safer better. It improves the ability for the salt to be effective. Do you have thoughts on that?
The BMPs are a great idea. Moving them forward in this bill, a great idea. Having them in place so we can all see what they really look like for safety standards, because we can't right now because they don't exist. Great idea. Sometimes it takes multiple phases of effort to get to a full outcome. And then with regard to the notion that abrogating negligence but leaving in place gross negligence is making a fair law for people. No.
Why?
Oh, okay. Gross negligence is a version of blatant disregard. Negligence is unreasonable action. And I would want to bring in the experts who've grappled with this for decades to really talk this out with you. You know, we are, you know, accustomed to bringing the safety concerns on tort law to the Judiciary Committee, and I'm more than willing to invest in your deliberations on that. But this is a new idea that just kind of has popped up in the last, call it 5 weeks. And there's, just like the New Hampshire witness said, there's not like a database of injury law. And looking for a negative, who was denied justice that actually deserved it, if you were their jury, is what this bill supposes. But it's not that easy to just wade into this and pick out one piece and say, Agency of Natural Resource shall write the safety standards and that'll be all good.
Is there any way of knowing or finding out how many cases, if there's not many brought to court, how many are settled?
And I bet there are a bunch because people are careless and people get hurt. Property casualty, I mean, DFR, I mean, this is a question of insurance. You know, I mean, like, people are insured for this purpose. So like, why do we want to block people getting access to getting their medical bills covered from a commercial premises insurance? I'm not sure. Using people's rights as incentive for an environmental law is going to run into some doubt in this regard. But it's really not runaway litigation. I mean, we're just not a litigious state. You know, there's not tons of unwarranted slip and fall. You know, people have insurance for it. They get a lawyer. The facts are looked at. They settle. Contributory negligence is often part of this. You know, you, the person who gets hurt, the justice system says, well, how careful were you along the way? And by the way, if it's over 51% your fault, fine. You know, like, the tort law has been crafted thoughtfully over hundreds of years. It will withstand a lot of scrutiny and make a lot of sense, you'll find. Now, how it's applied in other states and like, but products liability, premises liability, medical liability. Madam Chair, like, to take a medical procedure, it's a premises liability is a dangerous intersection. You know, I mean, life safety is at risk. The General Assembly is saying, write standards on this medical procedure. If you do it in this way, then you're presumed to have done it reasonably. You know, it's tough to wade in there and get safety standards right.
Representative Austin?
Yeah, I'm very confused, because I don't see this law as a safety law. I see it as a clean water law.
Understood.
So there must be another section of law that deals with slipping on ice.
Yes.
That wouldn't be this law. So when we give the drivers kind of this pass, if you take this class, what are they, could they be sued for? I mean, if we measured the water and the water had more salt in it, that might be one. That's what I'm like thinking. This isn't about keeping people safe, the way I understand it. it seems like there'd be another section of law or another corporation or the business law in terms of safety. So I'm just confused how
Yeah.
this is getting
I,
kind of.
I anticipated that and I'm sorry for that. And it is, yeah.
No, this is fascinating to me, very interesting, but I don't know what the driver would be sued for. If someone got into a car accident because there wasn't enough salt on the road, what's the liability that the driver has?
well, this is about, using a typical example, a commercial, the pharmacy at the mall,
Mm-hmm.
when there's black ice
Right.
a week after a storm.
But wouldn't Costco have that covered? Wouldn't Costco, if it was their parking lot, wouldn't they have insurance that?
100%. And we're trying to, my testimony is, let's maintain access to that and leave that alone, because on page 6 in the middle of the bill, you have a thing that says you're only liable for gross negligence, therefore immunizing negligent behavior. It's okay to act without reasonable care, harm someone, if you've followed these standards, is what the bill says. So it's the intersection of the environment's interest and the safety interest, which makes sense because people's feet touch the ground and I'm the people.
Yeah.
And you're the ground.
See, as two different things, and I don't know why you wouldn't just have to keep water clean like the environment, the water protection law that this is under. And then a different law that if you slipped in a parking lot or for at whatever reason that you were injured, that would be a different law. But what I'm trying to figure out is this kind of carrot that we're offering to drivers to take this class or get this certification. I don't understand what it does for them.
And in our version of this, you would
Yeah.
put these standards in place.
Yep.
And what it would do for them is that they know that's the standard they need to follow.
But they wouldn't get sued for injuries, for an injury occurring in the parking lot?
If they've acted unreasonably, then they would use these standards as a defense in a sense. But it's a question of fact. It's very hard to envision here sitting in this room, every circumstance.
Mhm.
Black ice, pharmacy parking lot, the pharmacy has notice. And how does this play out in?
That's not the intent of this law. When we talk about legislative intent, and I'm not challenging, I'm trying to understand law, So the intent of this law is to keep our water clean.
Yeah, but to promote that, you're saying,
Right.
I'm wading into the common law
Gotcha.
to define.
Can you think of another way to promote it where we wouldn't be waiting in?
Yes. And we're at the beginning of this journey, but this has been brought to you as like a turnkey solution. And we're here to say it's not that simple. And unpacking the intersection, your constituents are hurt through no fault of their own.
Right.
So I'm glad to be here raising the safety concern because but this is the nature of lawmaking. You're always out grappling with intersections. And so, but this is about safety at commercial premises. What is reasonable care? Right now, it's the common law. You folks want to wade into it, but the standards haven't been written yet. So it's very hard for us to engage in a conversation saying, well, those standards seem to add up. And so,
So we have other witnesses and other questions. So Representative Sakowicz.
I'm trying to wrap my mind around the nature of your concern. So I'm just going to try and state it and you can tell me if that sounds right to you or not. What I'm hearing is that if we were to have this bill become law, that there could be situations where an operator was truly negligent, but they were also following these best practices. However, they turn out to be written, as you say, they haven't been, we don't have them yet, right? Is that really the nature of the problem, that you could have situations where the standards that they would be trained for following don't envision enough sort of possibilities in the real world that there could be instances where they would still be actually negligent and but would not be able to be legally held so because they follow those practices. Is that what?
Yes.
Understanding you correctly?
Yes. There's some more to that I would want our experts to unpack with you, but at the center of the concern is that this is assuming these standards that have not been yet written are adequate for all circumstances with regard to safety. And that you'll end up intentionally blocking someone's access to justice that would deserve it.
Just as a comment, I guess it would be interesting to know if there's other places in the law where we already do this kind of thing. It just seems like we set standards all the time, knowing that they're not going to account for every single possible eventuality, but that if people make a good faith effort to follow the standards and that they're, doing so in a competently with some thought, with some thoughtfulness, that we typically don't hold them liable.
That's 100% accord with our position. We agree with what you just said. If you put the standards in the law, then they become the standard of care. They will play out in tort law. Wading in to then say, but I want to close certain doors for you to make these standards feel more important than they ought to be, so that people will go to class and do this, is a novel notion. Codifying a standard of care, yes, that's how you move it from vague to certain in a sense, but giving it the power of therefore then you are immunized. There could be no other circumstances, or it's the interactions of these things. Like, we write these laws assuming this is the way it will play out. And then it's time, frequency, notice, training. Like, there's a bunch in here. Hey, I mean, understand my position. There's no standards to look at this point to see it. This is not, here's some standards. You'll get a penalty, $100 fine. This is like, nothing goes to the heart of what it means to be writing law than safety.
The only other standard of care that I can think of right off the top of my head right now is medical. And legislatures are not codifying those. They come about through the AMA or through other professional organizations.
Yeah.
But how is that different from BMPs being created by professionals?
It's not. It just doesn't say that the American Medical Association's guide on how to do this procedure, if you follow it, then therefore you are immune from negligence.
So that's one of your solutions.
If you want to encourage people by having a standard of care, great, let's see it and let's understand it.
What's your other option here besides the standard of care? I mean, I know you said we could codify like we do with enforcement. So that's the other path forward here.
Or some gold star program that gets created that's like a distinction in the marketplace. Like, this wasn't how do we think this through? It was how do we copy New Hampshire and do what they did, which is jump to one particular solution.
And it's working there.
Is it? We don't know how. That's not what I hear. I mean, I have a bi-state network that says people are denied access to justice because of it, and that it's a morass.
Where do you hear that?
In the Vermont Association for Justice, when we talk to people who work with people who are hurt in New Hampshire, they say, oh no.
Who do we have on that topic?
I mean, next for us is Richard Rubin in the Senate Judiciary Committee.
I'm curious about the New Hampshire folks. Maybe you can give us some names offline. Or who to have in to hear about what's happening in New Hampshire.
Sure.
Yeah.
I mean, I don't have, I mean, okay. Yeah, I mean, they're not part, I mean, okay, sure.
I mean, if it's a morass and we are building this on their model, we need to hear both sides.
Sure.
Yeah, so that would be helpful.
But be mindful, there's nobody who it's their job to participate on this issue. I mean, like, I'll have to go digging for that. But for me to signal that this isn't that simple is not a controversial notion. And the idea that you can immunize negligence based on some pretty vague standards is also not a controversial notion.
Yes. Representative Moore.
Thank you, Madam. Thank you, Adam, for coming in. You confused me a little bit
Understood?
and attorney, in my mind, I can understand why. However, you're talking about liability here or negligence to some extent. And what this, in my mind, what this bill is setting up, it's a program for sodium chloride applicators are not spreading too much of the salt product to melt the ice and the snow. They're contracted usually by the business, the pharmacy at the plaza or the mall. And all this bill in my mind is saying is that there will be a program that will be set up to say that we can use this much salt and it is adequate to melt the ice. If they put twice as much down, the liability still stays there. If they put 3 times the amount down, the liability is still there. All this is, in my mind, is trying to do is release the applicator, if they're following a best management practice program, that they have put down an adequate amount of salt. The liability doesn't go away, but would go with the pharmacy. You mentioned they have insurance. And all this is, in my mind, is trying to alleviate it going from the pharmacy down to the applicator.
Interesting. Tricky to do that, but understood. And it's hard because when I hear you folks describe, if they put down the right amount of salt, they shouldn't be liable. That's the law right now.
Perhaps, but we have seen instances, and this parking lot out here is one of them, where the amount of salt, just the novice, and I do salt my driveways, et cetera, but the amount of salt that puts down in some areas just seems excessive. And is it any less slippery because they put more? And the answer, in my mind, is no. They put down enough salt to take care of the ice. When they have the freeze thaw from the rooftop or whatever, the drain, and you have freeze thaw, that's a separate application from the driveway or the parking lot that the commercial applicator put down the sodium chloride in under best management practices, once we get that stood up. You're always going to have, it's Vermont,
Yes,
freezing temperatures.
you assume risk when you go out and
There's a
walk
risk.
on the sidewalk.
The person that should, the elderly person that shows up at the doctor's office said to try to be the first one in line. And if you've ever been to the doctor's office or to get blood drawn early in the morning, they're always full of elderly first thing in the morning.
Mhm.
When I'm trying to go to work, they get there before the applicators have a chance to apply the sodium chloride. The liability is still there, but it's the property.
Well, it'll play out differently because Vermont juries are not distributing justice unfairly to the salt applicators or the property owners right now. So, and the notion that the applicator on commercial properties is always and only thinking about, am I going to get sued? Well, I know I want to be thinking about, am I making this safe? And I get that's kind of a little bit lost in this conversation here, but at the end of the day, when push is coming to shove, we need safe premises on these commercial properties. And so, it's a tricky intersection. That's for sure. But I'm trying to be positive on the idea that you can wade into this area of salt and start sending signals that will both help in litigation and help in the environment. We're just saying this, the way this is crafted, I think it's a bit illusory as a promise as well, for what it's worth. The New Hampshire experts, oh, people still get sued. So take this class, I won't get sued.
And one last question, then we need to move on. Representative
Not a
Bartholomew.
question. It just seems to me if New Hampshire's created a morass over there, that there would be people eager to talk about it.
Yeah, I agree. We'll see if there are. Thank you for your testimony. Very interesting.
Yeah. I anticipated it's unpopular.
It's very interesting.
Informative.
And yeah. Thank you.
Do we get a degree?
Robbie DeVoy joining us. Robbie DeVoy joining us by Zoom. Welcome. Okay, you're muted.
There we go. Good afternoon. Can you hear me?
We can.
Perfect. My apologies. I jumped on a little late here and got kind of half of the conversations taking place. Starting off fresh with the previous gentleman that had just spoken regarding liabilities. In a commercial snow removal application, this is a 13-page document. And this is a pretty standard document for a commercial snow removal contract.
Excuse me one moment. Would you mind just introducing yourself and telling us what you do?
Yeah. So my name is Robbie DeVoy, and I own and operate a commercial lawn care company, commercial and residential, and we provide snow removal in both commercial and residential applications in some pretty large properties. And we use quite a bit of salt in the conversation at hand here. So jumping back into this, in response to this bill and the drafting of it and the presentation of it, I think it's a great idea, and there are definitely alternatives that are available to help the reduction of salt, to improve the the water quality, the reduction of aquatic loss of life, and the vegetation. And these are the physical and the visual aspects that we see quite frequently, and it's becoming more prevalent in our area. And that's what actually caught my attention about this when it was mentioned, because I don't have any supporting data as far as the rising, pH levels or chloride levels in the water quality, but it's visual. You can see in some of these larger complexes that we do that have settling ponds, that have excessive runoff, a few of them actually abut wetlands, and you can see the decay of vegetation. It's visually present in all of the flower bed installations, the excessive spreading of salt, as the previous gentleman had just mentioned, that you can visually see it on the ground, and it's the effectiveness of it is not any better. So as I was mentioning, just while it's fresh in my head, this is a contract right here for an area the size of 15,000 square feet, or 1/3 of an acre, which is pretty standard in our area in Addison County for a commercial location with adequate parking. 5 of those 13 pages is regarding liabilities. So as far as the response in, trying to absolve or immunize liability for this particular industry, I personally believe it's almost impossible. There are, at a minimum, if the company that you're providing the service for is vetting their contractors properly, is 3 policies to provide snow removal. You have your commercial automotive policy for snow removal, then you have your general liability to help cover above and beyond that, and then you have an umbrella policy that covers that. So as far as removing any liability or immunizing the contractor in any way, I just isn't possible. And kind of bouncing around here a little bit, society in general has just been kind of pushed in a direction where instant gratification, removing any kind of inconveniences, so to speak, and living in a New England state and having snow on the ground is, as we all are aware, is common. And society has almost been trained where they're not to see any of those conditions when coming to a commercial location. You get out of your car at the grocery store and you're just your face is in your phone and you're walking blindly through a parking lot into the store with no regard to your environment. Which puts a lot of pressure on a contractor to provide a service for that particular environment. And, with the employment options that we have in this particular industry, the experience isn't really there, the care isn't really there, nor is the concern. So over application is kind of the go-to standard. So making operators aware of being vigilant, using different practices for ice management. There's calcium chloride, there's other aggregates that can be spread, the location and where snow is being moved or stored, the overall geography of the area and placement to help the reduction of the use of salt, limiting your runoff and so on and so forth. So there's really quite a bit to it. And it kind of boils down to a couple of categories. The contractor being fully aware and understanding of the service that he's providing. And it's not just pushing snow. It's not just ice management. It really can dive a lot deeper than that. And paying attention to the applications and providing it in an effective manner, in spot applications. Some of the properties that we care for in particular, they don't even want to see snow. Like it's just, it doesn't exist in Vermont. That requires some unique techniques, while maintaining the use of ice management products, because that particular location has a settling pond close by, and you don't see anything grow in it, let alone swim in it. So changing the societal thought process and how people engage in these areas is kind of where we're focusing. We are in the infancy of trying different aggregates, trying different practices to reduce our use of salts. And I wouldn't say we use, we're not one of the biggest players in town, but we're seeing a change in our clients. We're seeing a change in our environments by integrating a unique thought process. That's kind of all I had at the moment. Again, I kind of slightly came unprepared for this, but just
Fine.
in response. Go ahead.
I know we probably have some questions for you.
Okay.
So thanks for joining us. Well, you mentioned, well, I guess I'm curious are you familiar or know anyone who is in New Hampshire who's part of their salt reduction program,
I do not.
or heard any tale of the previous?
I have caught
witness?
wind from other contractors that are using different products. Nobody currently right now that I'm talking to is considering the conversation in a reduction of use. There's just, the industry has just become a consumer, and not really researching alternative products or application processes.
Would you be able to share with us as maybe a percent or a how much does the salt or the alternatives you're pursuing impact your bottom line or your budget? And like, is it enough so that learning how to apply better would help your bottom line, the cost of your products?
Yes and yes. So our market rate for 1 ton of salt right now is about $103 a ton. If you apply it correctly in its solid state, you can treat about 2 acres of property with that amount of salt, 1 ton of salt. If you can liquefy that same 1 ton of salt, you can increase your application area 6-fold. So by putting it in a liquid state, making calcium chloride or brine, you can really extend your application rate. It has a better, I shouldn't say a better effectiveness, it has an equal effectiveness as far as ice management. It is less susceptible to runoff because the treatment area of a granular of salt is somewhere around 3 to 4 inches. A single granular of salt, rock salt, will treat 3 to 4 inches. You put that in a liquid state, that same grain of salt will treat an area of 10 to 12 inches. And you're using the same amount and increasing it by 30, 50% in your treatment area. You can be a little more precise in your application process in a liquid form. It's less likely to track and it remains in its treated area. So that's a huge process right there. And then you can go to aggregates. So as far as reducing your bottom line, if you use an aggregate, i.e. sand, untreated sand with no salt additives, very incredibly cheap, very messy, which goes back to the societal kind of thought process. People see it, it's messy. It requires additional resources if they wish to have it cleaned off the property, but can be treated to reduce, or pardon me, can be used to for ice management and high slip areas, or as the gentleman had previously mentioned, a burst pipe, and you have a consistent water flow. No amount of salt is going to fix that. So you treat it with an aggregate, and then it reduces the impact on the surrounding area. So that's a possibility.
Further questions on the operation and functionality? I think we have a really unique opportunity here to understand how this might affect someone who's doing it in the field here. Yeah. Representative Morris.
Thank you, Robbie, for coming in and testifying, and I appreciate that. Maybe you weren't as prepared as you'd like to be, but I think you're doing a fine job. Have you ever been sued?
Thankfully, no.
And how many?
It's definitely a fear in the industry. Being a contractor and having ice management contracts, it'll keep you up at night.
And how many years have you been in business and you haven't had a lawsuit to date?
This is my 15th year.
Thank you.
And we have not had a suit as of yet. So, but I would like to mention my company operates with a high level of transparency and availability. And we, as part of our agreement, contractually with our clients, we are available 24/7, 365 at the drop of a hat for our clients. So if we'll use an HOA for an example, that we are available to every one of the HOA members if they experience a situation. We are responsive.
How many employees do you have?
6.
And are you familiar with other, I don't know, other property managers who have been sued in Vermont?
Not personally, no.
Yeah. Okay.
I've caught some third party stories, but nothing I can confirm. Yeah.
So how do you imagine interacting? Like if we pass this law and it becomes a voluntary program, would you engage in it?
Oh, absolutely. We've actually, this is something that I started last year. We were researching alternative products and alternative methods because I personally, you had mentioned the bottom line, what our budget is for ice management, and then looking at the effectiveness of it. We experimented pretty heavily this year with sidewalks of 5 and 8% grades, doing a brine mixture. And this year alone, it cut down our salt usage just for that particular location with that environment 50%. And we were still using granular salt as well, because we're trying to modify our system because there's there's a bit of a process to it, but, we want to transition, I want to transition into, a brine, using, 70% brine, 30% granular, or maybe even 20% granular and 10% aggregate, for our ice management, and try and maintain that level that society has become used to, where they can carefree walk around, or engage in an area.
That's great. And can you speak to a little bit of the cost in transitioning, or, we had a question about how do applicators monitor the amount of salt they're using? How do you monitor that?
So it boils down to the operator. I look at it. I look at the big picture. I see our consumption, and I can track it by storm. The operator, if you can maintain an annual operator that is in the same vehicle, same applications, same locations, they can really break down their usage to probably the 5-gallon increment as far as the application rate to a location. Just a broad example, I can load one of our units and he can do upwards of 8 properties, which is going to be somewhere around 3.5 acres, 4 acres that he can treat. And it falls on the judgment of, again, of the applicator. A lot of these applicators, they just get in a truck and they just turn it on and start driving and don't look back. I really try to engage with my drivers and my employees to focus, and both visually and audibly listening to their equipment and listening to the application process. And then, having the visualization of where it's going, how it's going, how much is going down. And I think everybody in the room can agree that there's been a point where you've pulled up to an intersection and see the state truck and the sander or salter's still going. It dumps, a couple gallons of salt right in a singular location. So you add that up 3, 4, 5, 6, 8, 9 times during a storm, and then suddenly you've got 1,000 pounds of salt that is just, needlessly casted on the ground, that contributes to the inception of this bill, why we're here. So proper training, as mundane as this task may sound, you really got to pay attention to what you're doing. So.
Well, thank you. It's obvious that you do, and I really appreciate your sharing your expertise with us today. Is there one more question? Representative Norris.
Yeah, again, thank you so much for your presentation. So is your primary interest in participating in this ultimately for just salt reduction, for cost reduction? Is that kind of one of the main driver you're looking at?
No. And I would like to go more green. I'd like to be more, environmentally friendly. It's moving into the future. And you've got to weigh your pros and cons. It's not always about the bottom line. It's about providing a better service for both the consumer and the environment. A lot of what my industry does is we operate on fossil fuels. And, if we can take that initial step in the right direction, it's a good start. So there's more to it than just an economical gain.
Okay, perfect. And then so your engagement in this program, were it to be put in place, would be primarily to take advantage of the training that would be made available.
Most definitely. Training is huge. Continuing education is huge. As an employer, I preach that. We just got back from a DigSafe seminar. I took all of my staff to a DigSafe seminar to learn firsthand, from either the manufacturer or the systems provider or what have you. But definitely training. And in this particular industry, I provide a commercial service. I'm vetted by our consumers. there is a whole nother level below that. And I don't want to say below that to sound derogative, but thinking of all of these individuals that are owner operators that are doing this at every level below a commercial provider. If you added all of that up as a whole, I bet at a consumer level would be astounding the amount of salt that is used there as well. Obviously, the state and municipal being the largest consumers, and then it tiers down from there. But training, making it aware to providers out there that it can be done a better way. There are other options and opportunities. Most definitely.
And so are those trainings not available for you now, or are there trainings that you could be taking advantage of even now, or?
No, to the best of my knowledge, from what I've been able to find in the industry, there is no training. There's that I've been able to find in this particular service being provided. Period. I mean, there are companies that manufacture brine systems that will come and show you how to operate their systems, but there's no training out there as far as providing a particular snow removal service, how to do it, integrated management plans, anything like that.
Okay, and okay, so the training seems to be most important, and how important to you is the limited liability reduction? It sounded like you're already 3 layers covered for liability, and so maybe that wasn't such a big deal. Is that what I was to take away from that comment?
No, it is still a major concern, and definitely it's still a focal point for the liability for this particular service. And as I had mentioned in that one, this one particular contract, 13 pages, and 5 of it is liabilities on the contractor. It's still concerning, but I don't think it's ever going to go away. It's manifested in such a way, and society has been ingrained in such a way that these contracts and these services have just absorbed these inherent responsibilities, and being aware of it is very helpful but concerning. You've got to do a better job. It's there for a reason, because somebody chose not to do what they were contractually obligated to do, or didn't care. And that's never going to go away. That's always going to be there, but protecting the contractor would be a benefit. Creating immunity is impossible. I don't think that'll ever happen.
Okay, so maybe I didn't ask the question quite right. If the law did not have that limited liability clause in it, but it was just a matter of providing statewide training so that everybody could reduce salt usage, and would you still be interested in it?
Absolutely.
Okay, thank you.
Absolutely.
That was what I was trying to get.
Great.
Thank you.
All right. Thank you again.
Yeah,
We really
thank you.
appreciate it. All right, members, we're going to take a 5-minute break, come back until the hour, and then we're going to hear from DEC.